Okay, good afternoon, everyone. Welcome to IAS Origin again. This is Anubhav Deepani, your faculty at IAS Origin. So, in our last session, we actually started a series where we would be solving the previous year question paper of the important subjects of UPSC Prelim Civil Services examination. In our last session, we started with the previous year question paper of polity. And in the last session, we studied some of the most important questions and their correct answer and their explanation of executives and parliament. And today we are basically going to study one more very important topic related to your polity, and that is basically going to be your constitutional amendments. Now, as we all know, that under article number 368, okay, we basically have the privilege to amend the particular constitution, and we basically use article number 368 for the constitution amendment bill. As we all know that there are basically three different clauses of constitution amendment bill, that is article number 368, clause 1, clause 2, and clause 3. Whenever we have to amend any constitution amendment bill under article 368 clause 1, we go with the simple majority of Lok Sabha and Rajya Sabha. And whenever we have to amend any law under article number 368 clause 2, we go with the special majority of Lok Sabha and Rajya Sabha. And whenever we basically go for article number 368 clause 3, we do the special majority in Lok Sabha and Rajya Sabha, plus we do the simple majority in half of the legislative assembly also. That means we take the consent of half of the legislative assembly also. So today we would be basically watching out for some of those questions which were directly asked in the UPSC prelims related to the constitutional amendment of Indian polity history, and those questions will be basically having the correct answers also. But the most important thing, that those questions will be having the detailed answers also. So you just do not have to focus on the correct answer, but the real knowledge will be in the explanation, because that is actually must for your examination. Because do remember, UPSC always repeats itself. If there is a question in 2022, so there was a correct option also and there was incorrect option also. So the explanation of incorrect option could actually become a question in 2024-25 prelims examination. So be focused on that also. Now let us go for this particular very first question which we have to discuss today. And this particular amendment related question was asked in the year 2019. There are basically two statements in front of you in this question, and you have to guess that which statement is correct. And then we would be basically looking at the explanation also. So the very first statement is the 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Now, the first statement is saying that was the decision or was the election of any prime minister was kept beyond judicial review under 44th constitution amendment 1978. That means, what do you mean by judicial review? Whenever there is a decision taken or implemented by the legislature or by the executive, and if the judiciary or the Supreme Court or High Court of any state thinks that that particular decision taken by the legislature or executive is actually violating the basic structure of Indian constitution or violating the fundamental laws, that particular decision can be cancelled out by the judiciary of India. This particular cancellation authority of judiciary is basically known as judicial review. So here it is asking that, is it the statement correct that under 44th constitution amendment 1978 was it said that if the election of the prime minister was done in unfair manner, so can the Supreme Court of India cancel that particular election? Yes or no? This is our very first statement. Now let us go to the second statement. Is the Supreme Court of India struck down the 99th Constitution Amendment of India as being violative of the independence of the judiciary. Now you need to basically focus that which of the statement is correct here. And now if you basically go for the answer here, you will get to know that option number B is correct. That means Your second statement is correct here, and your first statement is completely wrong here. Now, let us try to understand the explanation of each and everything here. Okay. Now, see, the explanation basically tells you here that it was not the 44th Constitution Amendment 1978, but it was the 39th Constitution Amendment 1975. This was that particular constitution which said that the election of the president, election of the vice president, election of the prime minister, election of the speaker is actually beyond the judicial review. And this particular constitution amendment was basically passed during the emergency implemented by the Indira Gandhi government. Because in that particular scenario, let me just tell you the exact date of that particular emergency also, and that was 25th of June 1975. In this particular, on this particular date, it was decided by Indira Gandhi government that emergency will be implemented. Why? Because of the internal disturbance. So what was the story behind this? The story was that the Lok Nayak, J.P. Narayan or Jay Prakash Narayan was the biggest competitor of Indira Gandhi in the opposition party, and J.P. Narayan was basically leading the Janata Party of that time, and J.P. Narayan had that particular intention to remove Indira Gandhi government from the power, and Indira Gandhi thought that it could be actually a dangerous thing for her, and she does not want to leave the post of prime minister. That's why she implemented the emergency in the era of 1975 in the name of internal disturbance. This is basically the scenario here. Okay. And there was a important case also here in Indira Gandhi versus Raj Naren case. The 39th amendment was removed by the doctrine of basic structure by Supreme Court of India. Later on, in the Raj Naren case, Supreme Court said that the Prime Minister election or the President election, the Vice President election or the Lok Sabha Speaker election cannot be beyond judicial review. That means it should come under judicial review. That means in the Raj Naren case, Supreme Court said that if there is a scenario of any kind where the election of any mandate has been in a very wrongful manner, so Supreme Court can cancel that particular thing. Now, this was implemented under the 39th Constitution Amendment, but this was again removed by the Raj Naren case versus Indira Gandhi by Supreme Court itself. So you do need to remember that also. Now, the second statement was correct. That was the 99th Constitution Amendment. Now, when this 99th Constitution Amendment was passed, the 99th Constitution Amendment was passed in the year 2014. Now, what is the story here? Now, this particular story is completely dependent on the appointment of the judges of the Supreme Court. See, we all know whenever we talk about the appointment of the Supreme Court judges, we talk about the first judge case of 1982, then we talk about the second judge case of 1993, and then we talk about the third judge case of 1998. Now, third judge case of 1998 tells us about the appointment process of the Supreme Court. Now, in that particular third judge case of 1998, it says that the judges of the Supreme Court will be appointed by the President of India, and President has to take the advice from the Chief Justice of India, and Chief Justice of India's advice will be binding on the President of India. Correct? But before Chief Justice of India gives any advice to the President of India, Chief Justice of India himself has to take the advice from the four senior most judges of the Supreme Court. Now, this is the process of the appointment of the Supreme Court judge under third judge case of 1998. And this process was going on from 1998 to 2014. Now, in the year 2014, Narendra Modi government came into power for the very first time. And Dr. Ravi Shankar Prasad became the Law Minister of India. Now, Ravi Shankar Prasad said that here the Chief Justice of India or the Supreme Court senior most judges are giving the advice about the High Court judges that they should become or should be appointed as the Supreme Court judge or not. So there is a chance of corruption because the judges could actually recommend those people who are their relatives or family members or they are in their friend circle. That means Ravi Shankar Prasad in short said that there is a problem of nepotism and corruption in appointment of the Supreme Court judges. That's why Ravi Shankar Prasad passed a constitution amendment bill with the special majority in Lok Sabha and Rajya Sabha, and that particular constitution amendment was known as National Judicial Appointment Commission. Now, this National Judicial Appointment Commission actually cancelled the third judge case of 1998 completely, and this third judge case of 1998 was cancelled, and a new law was basically brought in front of the government and in front of the judiciary. And under this National Judicial Appointment Commission, which is also known as NJAC in short form, this particular commission said that the appointment of the judges of the Supreme Court can be done by the president only. That is one thing. But the president will not take the advice from the Chief Justice of India. There will be a proper committee to advise the President of India, which will include the Prime Minister, Leader of Opposition in the Lok Sabha, Leader of Opposition in the Rajya Sabha, Lok Sabha Speaker, Deputy Chairman of the Rajya Sabha, Law Minister, Secretary of Law Minister, Home Minister, retired Chief Justice of India, retired Supreme Court judges, etc. So in this particular scenario, what happened? That judiciary felt that here the executives are interfering in the matter of judiciary. And Supreme Court said that this particular National Judicial Appointment Commission is the direct violation of Article number 50 of Indian Constitution. And Article number 50 tells us about the separation of executive with the judiciary. So here the Supreme Court of India said that we will not be able to allow National Judicial Appointment Commission, and we are cancelling the 99th Constitution Amendment 2014, that is the National Judicial Appointment Commission, and this was basically struck down. This NJC was struck down in the year 2015. That's why you basically see the second statement of this question is completely correct here. Okay, now let us basically see the explanation of 44th Constitution Amendment 1978 also. Okay, so now this 44th Constitution Amendment 1978 had the major role in cancelling the 42nd Constitution Amendment 1976. Please try to understand this thing, that when this 42nd Constitution Amendment 1976 was going on, there was Indira Gandhi government in the center. And Indira Gandhi and Congress government lost the election in the year 1977. Janata Party made the government, and Morarji Desai became the first non-Congress Prime Minister of India in the year 1977. So whatever illogical laws were made under 42nd Constitution Amendment 1976, all of those laws were cancelled and struck down in the 44th Constitution Amendment 1978. And there was one more very, very important thing here, that under this particular 44th Constitution Amendment, there was Article number 31, which was known as right to property. This particular Article number 31 was shifted to Article number 300A. That means before 1978, right to property was a fundamental right. And after that, right to property was basically converted into a legal right. You can basically read down the same thing here. That is, right to property was removed from the list of fundamental rights. That is Article 31, and was made a legal right under Article number 300A. So this was basically the 44th Constitution Amendment. 44th Constitution Amendment 1978 did not have any kind of relation related to the election of the Prime Minister and President of India. That's why the first statement was incorrect, but the second statement was exactly correct here. Now let us go to the next question. And the next question was basically being asked in the year 2019. And this particular question is related to the 9th schedule, that is the very first Constitution Amendment. Now, this question was again asked in the year 2019. It was said the 9th schedule was introduced in the Constitution of India during the Prime Ministership of 2019. Okay, so here, in who was basically the Prime Minister? See, 9th schedule was basically implemented in which year? It was implemented under the first Constitution Amendment of 1951. So in the year 1951, who was the Prime Minister? Obviously, very common sense, Pandit Jawaharlal Nehru was the Prime Minister here. So this was a very easy question. Now let us basically look at the explanation here. So under the first Constitution Amendment 1951, what exactly happened was that land reforms were implemented. Land reforms in the sense, during the Britishers' time, the people who were basically having the maximum of the land, which were basically the captured irrigated land by those people who were given the titles of Zamindar, Sahukar, Patel, Lala. So government said that you guys cannot have that much of land. The maximum limit of the land was basically set till 5 acre. Like for example, if you are a zamindar, let's say if you are a zamindar of the 1951 era, and let's say you have the total land area of at least 15 acres. Okay, so here government said that we will be taking 10 acres from you and you can just have only 5 acres. This law was basically known as land reform, and that particular 10-acre land was distributed to the landless laborers or landless agricultural laborers. This law was basically known as the land reforms. Now this land reform was included into a new schedule, which was basically the ninth schedule. Now, right now, if you see in 2024, how many schedules do we have in the Indian Constitution? We have total of 12 schedules, correct? But 12 schedules were not there in the original constitution. In the original constitution, there were only 8 schedules, and the ninth schedule was basically made up in the year 1951, and this particular land reform was basically included in the ninth schedule. And what the Pandit Nehru government said about the ninth schedule, they basically said that if any of the law which will be basically put under the ninth schedule, that will not be coming under the judicial review. So the rule of the government was that if there is any law which will be under the ninth schedule, Supreme Court cannot struck down that particular law in the name of the judicial review. Okay, now let us go for rest of the explanation also here, that it contains a list of the central and state laws which cannot be challenged in the court. And now here the Pandit Jawaharlal Nehru government said that there are basically different types of list in the seventh schedule, that is the union list, state list, and concurrent list. So if there are subjects under the union list or state list or concurrent list, so here Pandit Jawaharlal Nehru said that we will not be if we will be basically amending any kind of law, whether it is the subject of the union government or whether it is the subject of the state government, and if we would be putting that particular subject under the ninth schedule, we can actually do that particular thing. And currently, if you see that in today's time period, there are 284 laws which are there under the ninth schedule. That means these 284 laws cannot go under the judicial review. That means these particular laws are basically beyond judicial review. Now, this particular ninth schedule has a very direct connection with the Keshavanand Bharti case of 1973 here. Please understand this point. Okay, right now today there is Vaman Rao case. You might have basically heard about that particular case here. Vaman Rao case of 1981-82. So here, this Vaman Rao case is very, very important. In the Vaman Rao case, Supreme Court said that it does not mean that government has basically created a ninth schedule. So whatever law they want to include in that particular schedule, they can include, and they can basically put any law beyond the power of judicial review. No, sir, this is not going to happen. Supreme Court said in the Vaman Rao case that all the laws, please listen to this very, very carefully, all the laws which were included in the ninth schedule till the year 1973. This is a very important statement. Please listen to this very carefully. Vaman Rao case 1981-82, Supreme Court said that the laws which are basically made by the government and they are put under ninth schedule till 1973. Till 1973. only those laws cannot be basically struck down by the judicial review. But the laws which are made after 1973 and they are put under ninth schedule, they are under the judicial review. I'm repeating the same thing again. Please listen to this. This is very important, very complicated. In the Vaman Rao case 1981-1982, Supreme Court said the laws made by the central government and put under ninth schedule till the year 1973 will not come under judicial review. But the laws made by the central government after 1973 and put under ninth schedule, they will be coming under judicial review. So this is basically very, very important here. And why the Supreme Court basically took the time period of 1973, because in the year 1973 there was Keshwanand Bharti case, and Keshwanand Bharti case basically said that we can basically put judicial review in any of the law which we want. But this particular Keshwanand Bharti case was later on cancelled by the Indira Gandhi government again, by the 42nd Constitution Amendment 1976. So there was a hustle going on between the central government and between the Supreme Court. You need to understand the whole process starting from the Shankari Prasad case of 1951 and it went up to Vaman Rao case 1981-82, and that is basically called as the basic structure of Indian Constitution. Like for example, the first Constitution Amendment 1951 was there, land reform scenario. Against that particular constitution, Shankari Prasad versus Government of India 1951 case was there. Then it was the Golaknath case of 1967. Then against that, there was 24th Constitution Amendment 1971. Then against that, there was Keshwanand Bharti case 1973. Then against that, there was 42nd Constitution Amendment 1976. Then against that, there was 44th Constitution Amendment 1978. And then against that, there was Minerva Mills case 1980. And then to support Minerva Mills case, there was one more case known as Vaman Rao case 1981-1982. You can basically rewind this particular video and you can note down all the Constitution Amendment and judicial review, which I just told you, because that is going to be very, very important for your prelims examination. Fair enough, everyone? Okay, now let us basically go to the next question here. Now, if you basically see the next question, that basically was asked in the year 2013. And there are two statements here in front of you, and we need to basically look that which of the statement is correct here. Okay, just give me a moment, please. So here you can basically see the very first Constitution Amendment here. First statement here, and that is an amendment of the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. Number one. So this statement is correct or incorrect, we will see. Now, second statement is, if such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of the states of India. Now, here the correct option is neither one, neither two. That means both statements are incorrect here. Now, why both statements are incorrect here? This answer we will basically find in the particular solution. Now, we all know that the Constitution Amendment Bill is there under article number 368. So we do not have any problem related to that. That is very, very simple, and the NCERT level of knowledge is that. Okay, now let us go to the explanation of this particular Constitution Amendment. Now, an amendment can be initiated only by the introduction of a bill in either house of the parliament, not in the state legislature. So please remember this, that if you need to present or introduce any Constitution Amendment Bill, this particular Constitution Amendment Bill can be basically introduced either in the Lok Sabha or in the Rajya Sabha. Please understand this point. Okay, but it cannot be introduced in the state legislature. Number one. Then the bill can be introduced either by the minister or a private member. Now, I hope that you guys have watched the last YouTube session of this particular PYQ, in which I told you that any member of parliament who's having the ministry will be known as the minister, and any member of parliament who's not having the ministry is known as the private member. Now, it also does not require the prior permission of the president here, guys. Why? Because it is the money bill where the prior permission of the president is required. It is not the constitution amendment bill. Okay, now each house must pass the bill separately. It will not be basically passed in the joint sitting. It will be passed separately in the Lok Sabha and then in the Rajya Sabha. And please do remember, just like the ordinary bill, there is no provision of the joint sitting. And if you need to basically change the federal structure of the Indian Constitution, it is basically ratified by the simple majority of half of the states here. So this is basically the explanation here. And the president of India does not have any option. The president has to basically give the assent to the constitution amendment bill. The president neither can withhold the assent nor president can return the assent. So it is just one option in front of the president, that president has to give the assent to the constitution amendment bill. Now let us basically go for the next question related to the amendment. And this particular question was asked I'm so sorry. This question was basically asked in the year 2008. Now, this question basically tells us under which one of the following Constitution Amendment Act 4 languages were added in the language under the 8th schedule of the Constitution of India, raising their number to 22. Now, first of all, let me just tell you that out of the 12th schedule, there is 8th schedule. Okay, 8th schedule is there, and this 8th schedule tells us about the official languages. Right now you will basically see 22 languages here in the 8th schedule. Okay, so the question is, at one point of time, these 22 languages under the 8th schedule were not the 22 languages. They were just the 18 languages. But later on, through which particular constitution amendment, 4 more languages were basically added in the 8th constitution. And the correct option is the 92nd Constitution Amendment Act. Now, please try to understand this particular thing is that under the 92nd Constitution Amendment, 4 languages were added here. Okay, and those 4 languages were Bodo, Dogri, Maithili, and Santhali. These are the 4 languages which were added under the 8th schedule in under the 92nd Constitution Amendment Act. Fair enough? Please remember this point. Now, you just do not have to study the correct option explanation, but we have to go for the wrong explanation also. Now here you see that many other constitution amendment acts are there. Now 92nd Constitution Amendment Act is correct, but here the 93rd Amendment Act is incorrect, 91st Amendment Act is incorrect, and 90th Constitution Amendment Act is also incorrect. But what is the explanation of rest these 3 constitution amendment? You need to study that also. Now let us go with the 91st Constitution Amendment Act here. Now 91st Constitution Amendment Act came in the year 2003. Okay, it also brought some of the amendment in the anti-defection law, which was basically implemented by the Rajiv Gandhi government in the year 1985 by the 52nd Constitution Amendment. Okay, now what was the decision taken under this 91st Constitution Amendment Act? The decision which was taken is that the amendment said that the maximum number of the Council of Ministers, please understand this very, very carefully, that the maximum number of the Council of Minister will be just maximum 15% of the total members of the Lok Sabha. Total members of the Lok Sabha. That means how many Lok Sabha members are there? 543 members are there. Now, if you go for the 15%, near about 82, 83. So this is basically the maximum Council of Ministers number can be there. And this not just is implemented in the Lok Sabha, but it is also implemented in the Vidhan Sabha or the Legislative Assembly scenario. Because the same Constitution Amendment, that is the 91st Constitution Amendment 2003, said that the Council of Ministers in the Legislative Assembly will be also only the 15% of the total members of the house, and this also is implemented in the union territory legislative assembly also. For Puducherry also it is 15%, for Jammu and Kashmir also it is 15%, but here is the exception, guys. For Delhi it is not 15%, it is only and only 10%. Now you see how many legislative assembly members are there in Delhi. 70 legislative assembly members are there in Delhi. And how much is the 10% of 70? That is only 7. That means, according to the 91st Constitution Amendment Act 2003, the maximum Council of Ministers number can be in Delhi. That is just 7, including the Chief Minister of India. Now, you see that many of the times it is being criticized about Arvind Kejriwal, that Arvind Kejriwal is a very selfish chief minister and he basically keeps the maximum of the ministries and all, and he does not give opportunity to rest of the members to become the minister. He cannot do anything because it has been made law by the Atal Bihari Vajpayee government in the year 2003. It has been basically told to the legislative assembly that only 10% of the total members will become the Council of Ministers. That's why Arvind Kejriwal is basically appointing only, is basically advising the Lieutenant Governor of Delhi to appoint only 6 Council of Ministers, and 7th member he is himself. So this is basically the scenario. Now you basically go for the next constitution amendment also, that is the 90th constitution amendment also. It basically tells us about the reservation of the Bodoland territorial area in the Assam Assembly. Okay, and here the 93rd constitution amendment tells us about the reservation related to the other backward class, that is basically the 20% reservation in the private and government education institution. Now you see that 93rd constitution amendment is directly related to the Mandal Commission of late 1980s, which basically advised about the reservation of the other backward class. Fair enough. Now let us just go to the next question also. Now this particular 2007 question was asked here, that which of the following Constitution Amendment Act seeks that the size of the Council of Ministers at the center and the state must not exceed 15% of the members of the Lok Sabha of the total members of the Legislative Assembly. Now you see here that the question is directly repeated here. Now you know the answer, that is 91st Constitution Amendment 2003, and the explanation is exactly correct. Now this is what I basically wanted to tell you, that UPSC completely repeats itself. Now you please look at here. Okay, in 2008, the wrong statement was there, that is 91st Constitution Amendment. And here 1 year ago the question was basically asked related to the same constitution amendment, that is the 91st Constitution Amendment, about the 15% of the maximum strength of the Council of Ministers of the total members of the House. So this is the interesting thing which I basically wanted to tell you, that if you go for the previous year question paper, it will be basically very, very easy for you to understand that how UPSC basically repeats itself. Okay, now the correct option was obviously the 91st Constitution Amendment, but let us look at the incorrect options also. Now there was 95th Constitution Amendment Act also, and what it actually tells you about, it tells you about the reservation of the scheduled caste, scheduled tribe and Anglo-Indian in the Lok Sabha from the 60 years to the 70 years. Now what is basically this 95th Constitution Amendment is telling you? See, when our constitution was implemented in the year 1950, so the reservation for scheduled caste, for scheduled tribe, for Anglo-Indian were there in the Lok Sabha, Rajya Sabha and Legislative Assembly. But Dr. Bhimrao Ambedkar said that this particular reservation will be just for 10 years, not more than that. Okay. Now, in the year 1960, that particular reservation was basically again increased for 10 years, then again for 10 years, then again for 10 years, and again for 10 years. Okay. So under this 95th Constitution Amendment Act, this reservation was basically extended up to 2020. But in 2020, this Anglo-Indian reservation was basically cancelled. Now here you see, before 2020, how many members were there in the Lok Sabha? 545 members were there in the Lok Sabha, in which 543 members were elected by the people, and only two Anglo-Indians were basically nominated by the President of India. Correct? Now here today in 2024, if you see how many members are there in the Lok Sabha, 543 members in the Lok Sabha. That means the reservation of the two Anglo-Indians were removed in the year 2020. Fair enough. Now let us come to the 97th Constitution Amendment Act, and it basically tells you about the cooperative society or union under Article 19, Clause 1, Subclause C. Because from where this inspiration was taken by the government of India, the inspiration was basically taken by the directive principle of state policy, that is Article number 43, Clause B. Because this Article number 43, Clause B says that the promotion of the cooperative society and added part in the 9th B. Now, this cooperative society was basically made the part of Constitution Amendment. I'm so sorry, was made the part of fundamental right under the 97th Constitution Amendment. And under which article? Article number 19. If you want to go exactly and specific for that, so that is Article number 19, Clause 1 and Subclause C. This is basically the scenario here. Now, let us go for the next particular question. Now, this particular question is about 104th Constitution Amendment Bill. It is directly asked here that 104th Constitution Amendment Bill was related to what here? Now, this question was basically asked in the year 2006. Now, let us go for all the statements here. 104th Constitution Bill tells us about the abolition of the Legislative Council in the certain states. No. Introduction of the dual citizenship for person of Indian origin living outside India. No, India cannot have the concept of dual citizenship. That is basically the basic structure of India. Providing quota to socially and educationally backward classes in the private education institution. That, yes, this is correct. Okay, so this option number C is correct here. Now let us basically understand the explanation here, guys. Okay, now the 104th Constitution Amendment Bills tells us about the quota to socially and educationally backward classes in the private education institution. That's it, nothing more than that. Okay, now let us go for the next question, and this is also very, very important here. This particular question was basically asked in the year 2005, and this particular question is related to the 98th Constitution Amendment, guys. Okay, now there are basically 4 options in front of you, and you need to understand and tick and choose the correct option under the 2005 question. Now, this 98th Constitution Amendment Act is related to what? Is it related to the empowering the center to levy and appropriate the service tax? No, sir. The Constitution of the National Judicial Commission? Yes, this is the correct answer. Readjustment of the electoral constituencies on the basis of the population census of 2001? No, this is also incorrect. And the democratization of new boundaries between the states? No. Here, the option number B is correct in front of you. That is the Constitution of the National Judicial Commission. Why? Because 98th Constitution Amendment Bill 2003 tells you about the National Judicial Commission, which is basically included in the Part 5 of Indian Constitution. You just not need to read it out, but you please also need to make the notes also. Okay, please remember this point. Now you see here that again the land reforms or the 9th schedule question is again repeated here. Again in 2003 it was asked that the 9th schedule to the Indian Constitution was added by which Constitution Amendment? Sir, it was basically added by the first Constitution Amendment. 9th schedule was obviously first Constitution Amendment of 1951, through which we basically got the land reforms also under the Pandit Jawaharlal Nehru government, and through which we basically got the 9th schedule also. So it is very, very simple and logical. So no problem with this. Okay. Okay then. So let us go to the next question now. And this is the explanation, is the same explanation which I've basically given you already in the previous question. So you can basically see here how the questions are being repeated. Okay. Now let us go to the next question, that is basically the 2006 Three questions here. Which of the following constitutional amendment are related to the raising the number of members of Lok Sabha to be elected from the states? Now here there are basically two constitution amendments, the 7th constitution amendment and the 31st constitution amendment. Okay, now the 7th constitution amendment and 31st constitution amendment increased the numbers of the Lok Sabha members. Today, you see the total members of Lok Sabha as 543. It was not 543 in 1951, sir. It was just 489, something like that in 1951. But as we were basically growing in a population way, we increased the number of the Lok Sabha. Now, let us look at the explanation of this, and this is very, very interesting here. Okay, just give me a moment. Yes, now this is very, very interesting here, because this particular 7th Constitution Amendment Act amended Article 81 of the Indian Constitution. Okay, and it provided that the House of the People shall consist not more than 500 members. That means the maximum members strength was Lok Sabha was set at 500. Today in 2024, if you see how much is the maximum strength of Lok Sabha, it is just 550. But according to the 7th Constitution Amendment Act, it was decided as the maximum as 500. Now here basically you see that under the 31st Constitution Amendment, how much was the maximum number? It was just 525. And in 2024, how much is the maximum number you see is 550. Now in the 500 members, you see that not more than 25 members from the UTs, and here in 525 you can basically see not more than 20 members from the UT. So please do remember these two particular constitution amendment, that is the 7th Constitution and the 31st Constitution Amendment, through which the members of the Lok Sabha were basically increased here. Now there is one more question related to the constitution amendment that was asked back in the year 2002, and it was asked that which one of the following amendment to the Indian Constitution empowers the president to send back any matters related to the reconsideration of the council. It is very, very simple. That is 44th Constitution Amendment 1978. Now please understand the concept very carefully. Now, if you need to understand this particular concept, you need to compare the 44th Constitution Amendment 1978 against the 42nd Constitution Amendment 1976. So this is your 44th Constitution Amendment 1978 versus your 42nd Constitution Amendment 1976. Now, in the 42nd Constitution Amendment 1976, it was said by the Indira Gandhi government that the advice given by the Prime Minister and Council of Ministers will be binding on the President of India. Please understand this point. According to the 42nd Constitution Amendment 1976, it was said by the Indira Gandhi government that the advice given by the Prime Minister and Council of Ministers will be binding on the President of India. But this particular law was a bit changed in the 44th Constitution Amendment 1978. And in the 1978 44th Constitution Amendment, Morarji Desai government said that if any of the advice is given by the Prime Minister or Council of Ministers to the President of India, so President has this authority that President can basically return the bill for the reconsideration. But in the second time also, if the Prime Minister and Council of Ministers sends the same law or same bill or same provision to the President, then President must sign the bill. This is basically the difference. So here, if you are being asked that President was given the power to send back any kind of provision or bill for the reconsideration to the Council of Ministers or even to the Parliament of India, this particular power was given to the President of India under the 44th Constitution Amendment 1978. And what I have basically just told you, the same explanation you will basically get here also, that you can basically read out this particular amendment, that 44th Constitution Amendment was enacted by the Janata Party government mainly to nullify some of the amendments made by the 42nd Amendment of 1976. And Article number 74, Clause 1, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise to the President of India to exercise the function here. Fair enough. So this is basically your article number 74, clause 1 here. Okay. You also need to remember the articles also, because sometimes articles are also being asked in the examination, so you cannot basically take any risk here. Now there is one more statement you can basically read out. I have explained that thing, but again in a parliamentary language, no problem with that. That the 44th Constitution Amendment 1978 added that the president can send the advice back for the reconsideration once, but if the Council of Ministers sends the same advice again to the President of India, then the president must accept it. This is basically the portion here. So please remember this, guys, that we are going to continue this series. This was basically the second session. You will see the third session tomorrow again, and we would be solving the previous year questions till 15th of June, because on 16th of June 2024 there is your UPSC prelims examination. So it will be very, very helpful for you, so that if you basically do the test series also, and if you go for the previous year question papers also. Thank you very much. And I appreciate you that you are basically, guys, being very, very supportive to IAS Origin. And if you need to join any kind of courses to IAS Origin, please contact on the official number of IAS Origin. Expert mentors and faculties will be there on the call with you, and then you can basically have the further discussion and basically can make your journey UPSC, make your journey more easy of UPSC civil services examination. Thank you so much. I'll see you in the next session then. Thank you so much.